The Migrant Protection Protocol, MPP, or also known as Remain in Mexico, is a program that the Trump administration established in January of 2019. And what it essentially does is for all asylum seekers that are seeking asylum at our southern border, they are forced to remain in Mexico pending the adjudication of their entire asylum proceedings. So in order to expand MPP, or Remain in Mexico, the government has physically erected tent facilities in Laredo and in Brownsville, Texas, that opened up on September 11th and September 12th. And at these facilities, only MPP cases are being heard by judges that are video teleconferenced in.
The really important thing to know about these tent court facilities in Laredo and Brownsville is that these facilities lack any characteristics of a regular immigration court, starting with the fact that they've been rolled out with absolute operational secrecy, with no notice to the public, and there's limited access to attorney observers at these facilities. I attempted to enter the Laredo tent court facility on September 16th, and I was actually turned away by the Department of Homeland Security. We received different answers from the agency throughout the week as to why we were not permitted into these tent facilities. However, it became clear by the end of the week it was due to the fact that these facilities are located at CBP ports of entry.
After having been denied access at the Laredo Port Court, Laura, Lynch, and I went to the San Antonio Brick and Mortar Court because we were told that was the only way we were going to be able to view these proceedings.
What was most striking to me in San Antonio was the fact that there were, over 100 cases scheduled on the morning docket, and of those cases, only 2 were represented by counsel.
One of the individuals that came to court that day, she was at the Laredo Port Court, and we were watching her via video teleconferencing. The judge asked her what she wanted to apply for. Did she want to apply for asylum, the judge said, and she said no. And the judge said, well, what do you want to do with your case? And she goes, Your Honor, I would like to apply for refuge. And it's really a great example of how little information these migrants have because they're marooned in Mexico with no opportunity to have legal orientations and no lawyers to explain to them what the process actually is.
Remain in Mexico has numerous barriers to access to counsel, but even at these tent courts, this is a heightened problem because there really is not enough time for attorneys to meet with their clients in advance of these hearings or even to meet with their clients after the hearings.
DHS controls when the attorney is able to see the client, either before or after the hearing, and for how long they're able to see their clients. And so it makes it very difficult for the few lawyers that have gone down to the border to represent people in MPP, because what they see is EOIR really stepping out of the position of power over these immigration courts, and DHS having complete control over the processes and procedures of how people are representing their clients.
What we've also seen with these tent courts is the fact that video teleconferencing is very difficult for asylum seekers to adequately convey their case as well as their claim. And one of the most important factors in having an immigration judge determine an asylum case is the fact that they must determine the credibility of the asylum seeker. This is very difficult to do via a video screen, along with simultaneous interpretation and including any video feed glitches or sound issues that may arise.
Due process requires 2 things. It requires notice and it requires the opportunity to be heard. And so what we really see with the Remain in Mexico program is that people don't have adequate notice. The NTAs don't have the proper address. Oftentimes they don't have the proper hearing notice, or they don't have information, period. And so people actually don't know when and where their hearings are or if their hearings change. And they really don't have a meaningful opportunity to be heard, especially when we look at these port court court cases, right? Because when you are video teleconferenced into a brick and mortar court where the judge and the trial attorney is, sometimes literally the judge is unable to hear the respondent or the migrant in the port court. Individuals don't have access to counsel because they are stuck in Mexico with no attorneys that can represent them in Mexico. They don't have access to interpretation services or forms in order to actually bring their case and argue their case before the immigration courts.
After having visited the tent courts, it's clear that DHS is the one that is controlling the procedures as well as access inside of these courts. It's time that we have an independent judiciary that's separate and apart from the Department of Justice and insulated from the political pressures of the government. AILA will continue to ask questions and will continue to demand transparency from the agencies on this program.